Welcome back for those that went with us into the break as we begin this Kickstarter segment of Morning at NTV. 20 minutes to the hour of 8 a.m. We are going to take note of the legal and the political battle that is Besigye's incarceration. And with me in the studio, I'll be introducing guests who will be helping us with the critical insight as well as perspective into the goings on. And maybe at the end of it all, we shall be having an idea of how things will be moving. But before I do that, just a reminder, as our papers have carried today, that retired Colonel Dr. Kizza Besigye is expected to be produced to a court today, dead or alive. And that is the legalese, that is the habeas corpus. Using those words at this moment in time, when the man is struggling to be able to stand, sometimes apparently collapsing as he wakes in the morning, is very, very poignant. But we shall be able to get along and understand what is at stake and how this particular case or decision is likely to go this morning or today, to speak rather in general terms. I'm joined on set by lawyer Sam Muizi. He is one of the seasoned lawyers within the country, and his understanding of these matters is something that we don't take lightly. Most welcome to the program.
Yeah, thank you.
I'm also joined by Timothy Chimonges, a political analyst and user suspect. Welcome once again.
Thank you so much, Chris, and good morning to our viewers.
Great. Let's begin with the first things first. The High Court is set to decide on Dr. Besigye's release today. Would you love to, Simon Muizi, bring us up to speed with exactly what is expected to happen today, and then after that we can have a broader conversation around the implications and what may follow in the days ahead.
Yes, again, Sam Mulindo is my name. I'm one of the lawyers on Dr. Kizza Besigye's legal team.
My apologies, how did I skip that? Yeah, should
I've been on this since 2005 when this issue started.
Yeah.
Immediately I started practice on myself in this issue. It has been on, and we hope it gets a logical conclusion. This morning, aware of how the government has always handled such matters, immediately we received the Supreme Court decision, and suspecting that government may not comply, immediately prepared an application for unconditional release of our client. The same was fixed. First, it had been fixed for hearing on the 25th of February before the High Court, but luckily we've managed to get it fixed for hearing this morning, especially for retired Colonel Dr. Kizza Besigye. The other applications were filed in respect to other colleagues. Aaron Chiza, his is coming on the 25th still, but on health grounds we moved court to at least adjust and hear us this morning, and we are glad by 4 p.m. yesterday, as of 4 p.m. yesterday, we had secured a production warrant and served it upon the prison's officials to have him produced in court this morning for us to proceed with the application, habeas corpus.
Okay. Let me stay with you on that. The habeas corpus applications do take over any other thing that the court could be doing at that point in time.
Yes.
So there is absolutely no reason, technically, that the court cannot hear this.
Ordinarily, ordinarily, habeas corpus, most times it happens in people who have been, it is an application for people who are in illegal detention, especially by government. And the government, the onus is on government to give reasons why they should continue to hold him. Otherwise, he should be free today.
Okay.
Ordinarily, that should be the case. That is always not an easy bet when it gets to such matters. But we await. We've been at this so much for so long, and we are prepared as the legal team.
Okay, let's get some clarity again on this particular aspect. Sometimes legalese can be very complicated. Now, in the case of appearance in the habeas corpus application, if Besigye is unable to appear in person on account of his health condition,
it's about someone held somewhere for even a minute illegally. So it's an order to those that are holding him, who are known, that unless it is on health grounds that he cannot be produced to court. But I've seen such cases where we've had people coming in ambulance on a habeas corpus matter. At least the last I know, at least he can understand the proceedings. That's the precondition under which we believe we should be in court this morning, unless government again continues disobeying orders of court. This is an order of court. Producing him, dead or alive, is an order of court, which they should and ought to comply with this morning.
Mr. Chemonges, do you see government complying with this particular order, and most importantly, making sure that the now ailing opposition politician is brought in whichever condition he's in?
Yeah, so for specifically the production of Kizza Besigye before the court, definitely that's an order which has already been served, and the options are very limited, you know, on the on the side of government to produce Kizza Besigye. But also more importantly, it's probably to look at it from the perspective that the situation that we are dealing with is more political than legal. And the continued adherence or the continued argument around the legalese, you know, and when you see the statement by the president and all the other colleagues, it seems to be centered more on the question of the law. Yet this is a more, it's a political question.
It's a political question.
We've, as Council has mentioned, this is a matter that has been in place for some time, you get it. And that there are quite a number of things that you get to pick out of this. Is that one, there is a lot of interest from the side of state, specifically the individual, and looking at the statement of the head of state. There is high level interest on the first on the person of Kizza Besigye, but also on the whole process. Secondly, I think that you get to pick to understand that the Kizza Besigye himself, his situation seems not to worry or bother those that should be bothered. His state of health and whatever he could be going through is not one of those that really, at least from the statement of the head of state that was issued yesterday. But also I would want to invite us to, of course, look at this for Kizza Besigye as a sample of the many who are facing these challenges in prisons, and really they don't have the leverage or the advantage of what Besigye is. And so there is a fundamental problem in how, as a people, as government, are dealing with the question of the law, but also how we're handling our politics. And so, as you've asked, I think the state, specifically for this matter, will definitely have to comply. The biggest question is what looks like after he's been, if court asks that he's released. The biggest question is will court allow him to go home? There could be instances where he could be rearrested.
Because there is that drama that always follows. It is a familiar script, and you see it playing out today.
Absolutely.
If it does, what would be the ramifications this time around?
I think that there's been quite sufficient response from the public and also the international community. I've seen the Commonwealth and the other colleagues in different regions have come out of, although of course the hope is that you have more people putting pressure, but also demanding for fairness and for quick administration of justice, but also more importantly understanding that the question of politics is nowhere and it's everywhere, you know, and you see you can't place it, you know, you can't place your hand on it. And the continued insistence of this section and that section,
that contestation,
the contestation, and council here will agree that the biggest question is on the interest of those who hold the power, and to what extent they are willing to you know to concede on some of these things.
That's right.
And so I think that if he's rearrested, or if he's again taken back to court, to prisons, definitely I don't foresee a situation where there would be any bigger rising, or you know, the public coming out very strongly. But I think the question that we should be answering is on what does it look like on the adherence of the law, but also how we treat ourselves as a country. What sort of country are we dealing with? I think there has to be a sense in which the position of the law is respected, but also, more importantly, ensuring that beyond the question of the law, there is humanity in execution of these laws, but also and again, I'm very much aware that there are a lot of, as we head towards the 2026 elections, there are a lot of interest, there are high-level interest involved in this, and that to the extent that the public can be able to continue getting involved in this process, then those who are exercising impunity will always have their way.
Okay. Yeah. We'll be discussing the stakes ahead of 2026 a little bit later, so we can understand why this kind of treatment was meted to Kizza Besigye. Is there a fear that maybe he could reignite his political ambitions and want to contest for president? That will come a little bit later. But allow me return to council and roll back this step 3 weeks ago to the Supreme Court ruling, when it became clear, a highly anticipated decision, one that had required a lot of pressure. Yeah. I do not know whether this decision had already been written down and maybe shelved, and then it's only the pressure that led to the reading, because there was a judge who retired, and the ruling on that justice's part was done by another, meaning this was done and dusted. Yeah. But why it had stayed on the shelves within the Supreme Court is something that I do not understand as a layman. The political question versus the law, is this where the aspect of the judiciary maybe having to be cautious on certain aspects that might bring it onto a collusion course with the executive is supposed to be considered? Did it act on account of not wanting to collide with the executive, and then it's only the pressure that got too much and they had to release this particular ruling?
Well, I agree. Unlike other private matters, private governance issues, always sensitive. It touches on how the country will move, the stability of government. I would understand. But then when it comes to human rights matters and the law, the role of the court is to apply the law without fear or favor. And it's an independent calling or assignment or duty or obligation. It is true that there was no explanation. I was part of the team that went to the Supreme Court to respond to the appeal by the Attorney General in this matter of the Honorable Kabaziguruka. And we battled more or less the whole day just on an injunction that had been applied for by the Attorney General. And our issue was simple. For how long would you continue holding someone illegally? Our argument was that there was already a declaration by the Constitutional Court that this court was unconstitutional, and that holding anyone illegally in the balance of convenience, the government will not be hurt as much as the rights of our clients. Well, we respectfully agreed to the decision of the Supreme Court to hold what they said was a very temporary measure, to hold any execution of the decision of the Constitutional Court, and they were very clear that this would be very temporary. But that temporary measure took 4 years, 4 years, with the people being held illegally, even after a finding of the Constitutional Court. I think this was an ugly issue, by the way. We were talking about the executive, but we needed to have a self-check as the judiciary. How long shall we bow down to the executive arm of government? It's very clear that there is a lot of interference and overbearing by the executive arm of government on the other arms of government, and that is precisely what is happening. But it's just misuse of power, misuse of authority. The authority that you have over the judges determines how they'll act. But it's partly due to the law that gives the president overbearing powers. We have him as the appointing authority. Personally, as a lawyer on the team, I was not very optimistic that I would get a majority decision. I was just praying for at least a 4-3, because seeing the composition of that bench, I saw judges who had been shortlisted for being Deputy Chief Justice, now checking the authority of the appointing authority. It was very hard for you to count your eggs on that day. But that we got a majority said a lot. And true, this is a decision that would not take 4 years, especially one of the reasons that many judges along the way retired, others passed on. We've seen it is the law provides that you can substitute a judge in the interim. Temporary, you can have a sitting judge for a specific assignment. We are not short of such brains that could have made a decision in this matter. So that is a non-starter. I believe, like it has always been, with a client like Dr. Kizza Besigye, things are never the same. And this I've seen since I've told you my time of duration of practice with him. Always with him, things change. I think we need to understand that this is not about Dr. Kizza Besigye. It is teamwork. What we provide on the other side is the legal perspective as lawyers representing a client who appreciates the case, his own case actually. When you are representing Dr. Kizza Besigye, you are very sure he has at least 40% control over the matter that you represent, in which you represent him.
In fact, his decision not to take plea.
Yes, it is. It is always, because it's always a battle between him probably and his family and other players, and even the lawyers, because we always have different thoughts, but he's always in charge. Why? Because all these matters are political in nature. There's nothing much, like he said. It's not about the law. These are matters where you do not have to lose sleep. You burn the candles because you're going to court so that the law is applied. Most often in times, these are matters. Even the arguments we are making here can always have the day. It's nothing so technical in the law. It is always about authority and authority. And when it comes to the issue between the president and Dr. Kizza Besigye, things have been rather different. A lot of force, a lot of, overbearing on the judiciary. When it is a hot file always when it comes to courts, and it's about Dr. Kizza Besigye and many political opponents, like you've seen. These things have always been at the verge of an election, and a national election, and things happen. The drama
begins to roll out.
Yes.
There are elements who say perhaps the greater question is about political power and control, that somebody in State House fully understands where the threat is, and maybe that is what is conditioning these actions. But those are the musings of elements out there who might not have the facts together. Here on MorningAtNTV, we attempt to put those facts together so we can understand how things are playing out. When we return, we will ask, and this is something Council has just touched on, the fact that the judiciary continues to act in a manner that is not, of course, very convincing on its own independence. And does the question, or rather the political question doctrine, do play part in this whole thing? The need to leave some matters for resolution to the cabinet or the executive because it is not really a legal matter. Stay with us. We'll be right back.
When your business story reaches global markets, we have the world-class risk mitigation tools to help you thrive through the turbulence. At ABSA Corporate and Investment Banking, we are invested in your story, and we invite you to write it with us because your story matters. ABSA.
Never miss a moment, never miss a story. Stay informed anywhere, anytime with the revamped Nation e-paper. Now you can enjoy access with a superior user experience, improved layout for better navigation, ease of reading, and a more responsive interface on your device of choice. Remember, you can also access archive copies and catch up on news that you may have missed out on. Visit epaper.nation.africa to subscribe today and enjoy convenience at its best. For more information, email customercareug@ug.nationmedia.com or call us on 0312 301 230. Daily Monitor. Truth every day.
New Pepsodent Herbal, introducing a unique combination of natural ingredients with herbal extracts, salt and mint in an antibacterial formula for fresh breath, strong teeth and healthy gums that protects you and your family. Pepsodent Herbal, every smile matters.
Welcome back. I'm glad you're still with us. We are, of course, continuing with the discussion. Just before we went into the break, I posed the question or the sentiment about the political question doctrine. It's one of the issues that contested, and maybe some of the elements within the judiciary do find themselves in a sport of bother, where some issues considered political ought to be resolved by the politicians or the executive, and many insist or suggest Kizza Besigye's case is political in nature, and the resolution should be sought on that ground. Mr. Chemongis, it is plausible that maybe the facts, the issues regarding the constitutionality of the General Court Martial, of course we are trying to get context to where we are right now in light of today's decision, was down to the fact that all the legal minds agreed on the illegalities, but maybe what they needed to fine-tune were aspects, I'm sure, especially if the conversation we had off-air is anything to go by, was to simply ensure that everything is smooth for all parties.
Yeah, absolutely. So the position of court as and when you look at that ruling, my position has been that it was a bit vague. It wasn't very explicit. Of course, the expectation is that looking at the confusion of what's happening between the lawyers and the state, each pulling from their side, signifies a point of vagueness slightly on the ruling. I think that for many times such rulings should be very clear in terms of what should happen. Leaving no room for interpretation. Yes, and again, or leaving room for you to go back to them to seek for clarity, which will take again, some good time. Process, but again, I think you must also understand that the Supreme Court, beyond just being a court, there is also a question of politics that is played in there, and because of the consequences of their ruling. Part of the information, again, when counsel was highlighting, the information that we had received even before the judgment had been issued, was that the position of court, exactly as the judgment went, that was. But the biggest dilemma was around the sort of orders that the Supreme Court should have issued. But also, more importantly, looking at it from the perspective that the Supreme Court, again, this is a matter that had already been dispensed from the Constitutional Court, and there needed to be very clear positions. But again, the fear was that the fear was on opening up or providing a room where people who had faced the challenges in the court martial would open a Pandora of so many cases.
Everyone will be looking out.
Absolutely. So to be able to cover that gap, the ruling went as it is. But even as you see today, There is a lot of confusion. There is a lot of unclarity. The state, as listening to yesterday, the Minister of Justice is saying that they have not received any orders yet, and calling the lawyers very unserious for taking such a long time, you know, to issue or to serve them with the orders, which looking at it from the nitty-gritty, these are members who have been part of this process. You can't claim to be waiting for orders from somewhere and calling the others a bit unserious. It speaks to also their position. Him as a minister, the Minister of Justice, Honorable Norbert Mao, and the other colleagues, including the Attorney General. We've seen many times they've come on the floor of Parliament, and the position that they're giving is not clear. At some point, in fact, actually, when the Supreme Court had just issued the ruling, the Attorney General gave a different position. The deputy on the following day came and was giving, you know, slightly a different position. So it speaks to first of all where the interest lies in this. I think it does not lie with these individuals who are coming to give positions before the House. The actual power and the actual power lies with the State House and the individuals in there. But also, more importantly, I think giving a benefit of doubt to the head of state. He could be having information that we do not have, and that's it for
no,
him.
He's touted, of course, severally as the chief consumer of intelligence. And he has a lot more information that is not privy to the public or even the judiciary itself. But this takes me to my next question. Before we transition into that, I would like to have Council's take or submission on the political question doctrine. Is it anything that the judiciary grapples with?
Yes, indeed. And there's everything to see into this, the way this played out. To all legal minds, you realize that that it was very apparent that this was an illegal court. Everyone was surprised how even this law passed in Parliament in 2005, taking ordinary people to a military disciplinary committee.
Not as long as people can sleep and raise their hands when it comes to voting, a law can pass. So,
the courts were very consistent. Why there was a preconceived mind of all and sundry is that the Constitutional Court had several such matters. And in all this, it was very consistent that it was illegal to have people go to the General Court Martial. Actually, most of them, if not all, save for the one of the Honorable Kabas Guruka, were not even appealed against. It means the Attorney General government had conceded to this. And it was a consistent argument that having not appealed in these other matters, that was the position of the law, that court was illegal. But again, the political question came in, and that's why they had to hang on the issue of the injunction in the Kabas Guruka case, even when that was not proper. So that was politics at play. And you remember the Attorney General was always clear. There is a stay, and upon resolving the matter of the Honorable Kabas Guruka in the Supreme Court, then we shall abide. But after the decision, now you saw the tongues change. And I think it's about the pulse. They all, when you look at them, they are trying to feel the pulse of the president. What is thinking, what is stating. Actually, they even act, I think, on the Twitter communications. How is the president, if he's in Karamoja and comments about the judges, the following day you'll see them. Why do I state this? It was very apparent in the Supreme Court that all those lawyers from the Attorney General's chambers, the Deputy Solicitor General was there. They were in agreement of the decision. They were really not surprised about the decision. But that the tongues started to change, that is what we need to look at into as a political question. But that issue of saying that probably the president has the information that we don't have, I don't buy into that. Because he's been consistent. He doesn't believe in presumption of innocence. he has always really not believed that someone is presumed innocent, and that is what the overriding factor. It cannot be the same case with the same person handling it the same way. It is nothing but politics when it comes to Dr. Kizza Besigye. Even if there was anything, there's a smarter way of handling it. The way the whole matter was handled cannot survive in the civilian courts. That chain of evidence, the way it was carried out, investigations, it cannot pass. That is why it could only probably pass under his grip as Commander-in-Chief, head of the High Command, where the law even said that the panel of the chairman of the court-martial and panel had to even seek guidance of the High Command before making any decision. But I cannot leave this without answering the Honorable Norbert Mao. Sometimes I wonder if this is the man I served. I served the Honorable Norbert Mao as in DP. I was the National Legal Advisor until such a time when he brought an unserious document on my desk in trying to cooperate with the NRM. And I was very clear with him. I told Norbert Mao that the fish cannot live on the land, and neither can the birds live in the water. We are two different species, different ideology, different approach. We cannot have a marriage of convenience, like he was putting it, that it would be country first. We join issues. Since that Norbert Mao that I served as a National Legal Advisor, and seeing him on TV being very dishonest, it is not true, for the record, that we did not extract the orders. Immediately we left the court. It was a Friday. First thing Monday was the orders. And that's why we moved to the chambers of the Attorney General, if anyone recalls. First thing, we went to the Commissioner of Prisons. We told him the orders took immediate effect, and government is on notice. The orders, the decree that he's talking about, is about giving notice or even a summary of what the court decided. We went to the commissioner, that was the argument. We proceeded to the Solicitor General, actually to the Attorney General's chambers, and had a discussion with the lawyers. We phoned them with the summary and the implications of the decision, and they said they would comply. And government actually partially complied. At the same moment, we went to the Commissioner of Prisons. A different team went to Machindi, to the General Court Martial, and went there. They told us, no, we've received information from the Attorney General that we cannot sit. The General Court Martial told us on that day, the 3rd of February, that they could not sit in compliance of the court order. Again, the Commissioner of Prisons told us that he could not produce our client in Machindi in compliance of the court orders. So it is just selective application. Where do I want to comply, and what touches the authority of the president that he will not be comfortable if we comply. That is selective, compliance. So there is the issue of whether the lawyers were slow or not. It does not arise in any case, and it was quite unfortunate. It came from a person you would believe is brighter than the answers that he's giving on the floor of Parliament.
Okay, thank you very much for what is no doubt a submission that offers a little bit of clarity. But before I transition into the President's letter, to understand the kind of information that he consumes, that is the intelligence, let me stay with Counsel and ask the question, as the General Court Martial proceedings were going on, the back and forth and the little, the few moments or times that you guys were allowed to listen to the prosecution in this case, on the charges that were brought against retired Colonel Dr. Kizza Besigye and his AD. Now that the President's letter is here, and he says that we might not know as Ugandans why this gentleman is incarcerated, it suggests a lot of things. What we do know right now that could give us an idea is the assertion by Winnie Byanyima, his wife, that he is held in a prison cell that is 7 doors into the confines of the prison. That indicates that he's a high-level prisoner, but what Winnie Byanyima says that that particular section is where terrorists are held. That should give you an idea of the kind of crime exactly that Kizza Besigye is facing right now. Was he plotting a terror attack? That is a question that has no answers for now, and maybe with more time and more information coming through, the media will be able to give a clear picture on that. But you are on the team that was in the General Court Martial proceedings. What kind of evidence was adduced, brought into play, as in this is why this gentleman was kidnapped the way he was kidnapped and scrambled from Kenya to Uganda?
You know, it's, I may not preempt, I don't want to talk about what I've not seen.
Okay.
But no lawyer will tell you worth the salt, will tell you that the way this matter was handled, that it can succeed. It cannot succeed. And some of these things we really try to bring in the law where it should not even really. There's nothing technical about knowing that the procedure itself. You know, you cannot sustain a case that has been handled in a wrong way. Even if there was to be a case, sometimes I think the handling of such matters cannot really survive. There's no process, due process of him being brought from Kenya to Uganda. You would hardly believe that you can tell any person that Uganda can charge a person for holding a gun in Kenya. Even it's not about the law, that Uganda can complain about a person holding a gun in Kenya. I think it should be.
Well, Kenya sees no issue with it.
Yes, when you know, these are things that you know, it's nothing but politics at play. The crime is political. By the way, it has become treasonous to stand against President Museveni and the regime, because all people who have attempted, you've seen it, and it comes at the verge of elections. Is it a coincidence that we are talking about things which happened in 2005 when Dr. Kizza Besigye was meant to stand in 2006? Is it by coincidence that when the Honorable Robert Kyagulanyi Sentamu declared these intentions, again we found a gun planted on him, and can you ask what has happened of that charge? If at all it was as serious as, if you went back to the same letters, you'll find similar script. It doesn't change. The similar letters, if you went back in times, and comments, and are the same, just different in diction, but same statements from the president when it came to the Honorable Robert Kyagulanyi Sentamu about the gravity of the offense he attempted to overthrow. They even wanted to kill probably the president when they were in Arua. It was an attack. What has become of those charges, if at all they were proper charges? So it's a political question. It's nothing legal. I would not say that I've dug deep into what they have on file, but the procedures that they went through cannot sustain in the charge in the civilian court. And that is why I don't believe they are comfortable even producing him in the civil courts, but probably will attempt in trying to reinvent the military court, which will be illegal.
Chimonges, the president's letter.
Yeah.
It has all the hallmarks of, first and foremost, a lack of confidence in the fact that the civilian courts can handle the cases as sensitive as Kizza Besigye's. I don't know whether that should be an indictment of the judiciary itself, and that it's only military men and officers who have the wherewithal to handle cases that involve men like Kizza Besigye.
Yeah, so I think when you look at the question of, when you look at how our country is structured, and looking at how the military, as the question of militarism in the country has continued to be exercised, you will notice that there seems to be an understanding that the only institution or the only individuals who seem to understand, especially matters on security and what have you, but also looking at the question of governance now increasingly, where we are seeing military personnel, you know, working towards transition. It's a mentality question. Yeah. And when you further see now the Chief of Defense Forces, his remarks, when you corroborate that with with the head of state, you clearly see that there is the question of the military and their role in protecting specific interests in this country comes in very, very, very strongly. But also, more importantly, I think that when you look at the letter of the president, there are three things that stand out for me. Yesterday, as civil society, we issued a statement, in light of this, and we're trying to give our position in light of the other stakeholders who have called on government to adhere to the rule of law, but also, more important, to respect on the rights of the individuals, both Besigye and the other members who have been greatly affected by this process, including the Karachunas, the Karamoja individuals. So we have a big number of people who ideally should benefit from this process, and Besigye is simply reflecting the front picture. The first thing that comes out very strongly for me is that the president seems to be heavily invested, and this is one of the letters among the many that he has issued in the recent past on the same matter, which speaks to a point that President Museveni has already formed a position on this matter, and that he is aimed or is interested of pushing that agenda to whoever is interested in listening or picking. And what Council highlights here, unfortunately, the people that serve in government, the level of confusion and the level of picking the pulse of the president creates a lot of confusion. And you see most of them, and this is not all of them, most of them trying to pick an understanding where is the president's mind at this. And so many times they end up picking a wrong signal, or they end up picking the signal that they feel at that time will serve the interest of the head of state, which greatly compromises the processes, the interest of the country, but also the rights of the individuals, Secondly, even part of this process of execution of the Supreme Court ruling, I think what is causing the confusion, yes, the head of state has come out very clearly, but in trying to create a balance between the law and what the head of state is trying to push or is trying to communicate, you find that a lot goes, the process, the law, the rights of individuals are greatly compromised. Secondly, I think that looking at what Winnie Byanyima shares in light of the experience in prison, but also looking at the remarks by the president, it comes to me that President Museveni seems to appear as though he doesn't know Kizza Besigye, as though they are not comrades. These are people who have been together. You will actually get the signal that this someone President Museveni just heard from the street, from the papers, and is trying to understand who this is. And yet these are people who have...
I mean, I'm glad you bring up this. In his letter, he says, if you are innocent, why do you not demand for a quick trial so that you can prove your innocence and expose those who are persecuting you instead of demanding bail, forgiveness, as if serious crime is also entitled to holidays, That one is a statement that not only chokes my guts, but also brings the conscience of the nation into question. I thought all along, if somebody has an issue with anyone else, it is incumbent, in the words of, if we were to take Lord Mayor Lukwago's words, famous words, it is you who is supposed to come and ensure that you provide the evidence that somebody is guilty, not them to come and prove their innocence to you. It's quite disconcerting.
That's the constitutional position.
It's what I said. The president does not believe the presumption of innocence. But the bigger picture here between the two, it's very apparent. There's something between the two. When you are handling Dr. Kizza Besigye's matters, it's very clear that he knows the psychology of his opponent. He's always ahead of us in some of the strategic decisions when we're handling his matters, because he places M7 somewhere, the M7 that he knows, the M7 as he was with for quite some time. And often in times it comes to pass, some of these messages you see in the letters matters we have discussed before.
Yeah.
He always says at this level, this is what Museveni will do. If it's about power, if it's about authority, if it's about... So he's always spot on. So the psychology between Museveni and Third Colonel Dr. Kizza Besigye cannot be put on the side when you are discussing these matters. It's not merely about the law, but most importantly, as he says, knowing the psychology of President Museveni, Dr. Kizza Besigye is in this not for himself. If a person assessed how we've been handling these matters, they'll understand, like I said, it's not an ordinary client, client-advocate relationship. It is a partnership that the lawyers, including Law Society, because the matters I was talking about, Law Society was one of the first to file a petition, and it was in respect of Kizza Besigye's matters. So the Law Society has been in so much involved, and it has helped us so much in trying to advocate for the rule of law, in having a client or a partner, actually, in Dr. Kizza Besigye. And so many laws have changed, by the way. Just on the face of it, the cosmetics of it, you realize that whenever we go to the court martial with the Dr. Kizza Besigye, things change. The way we do everything changes. Either they are more stiff, but even the outlook, you realize when we went with Dr. Kizza Besigye to the military court this time round, the environment was quite different. When along the way you saw an uplift, a facelift of the premises inside the court. The ambience changed a bit, apart from the cage. That one has been very consistent. The cage, the way the cage. So for us, with him as a person, very resilient. His resilience has helped at least the lawyers to fight the psychology of Museveni, who does not believe that the law should work or that judges' decisions should work. And he was very clear in one of his letters or communications about whether judges can determine the course of events as far as governance of this country is concerned. Okay. But the thing I wanted to bring out,
very quickly,
it's not about Besigye. We brought about the Karachunas, the Karamajong.
Those Karamajong
those are the ones for us we are looking at. Beyond Besigye, for us, the lawyers are looking at the NUP supporters, the Karachunas. Those, what happens to them when there's no camera? What happens to them when there's no such a decision?
They don't have the kind of profile that Kizza Besigye has.
So with Kizza Besigye, you bring a profile which pulls out a decision of the Supreme Court, probably which should not have come out that fast. And that is, and what happens where there are no cameras? If before cameras, you could see how they treated our colleague, Aaron Chiza, you can imagine what happens without cameras.
Of course, there have been allegations of torture meted against some of the political or state prisoners by the military, and some of them have been well documented. Let's go for a break. When we return, we shall put wraps to this particular conversation as we wait for the proceedings that we do expect today, and that is on the release, a decision on the release of retired Dr. Kizza Besigye, who is currently incarcerated at Luzira prison. There is scanty information on his condition right now, but we do know that he is ailing, and medical attention is something that he needs very, very urgently. Stay with us. We'll be right back. Welcome back. I'm glad you're still with us. It's the half-hour mark, and as we enter the final bend of our discussion this morning, as we wait on the decision of the court on the release of retired Colonel Dr. Kizza Besigye, we are trying to put together the legal and the political ramifications and understand exactly how this is going to play out. Now, if at all it so happens that a decision is taken and retired Colonel Dr. Kizza Besigye is released, and that, I insist, is hypothetical for now, given the character and the culture that we've seen over the years, where people are released by courts but rearrested soon as new charges are brought against them. My guests are Timothy Chimonges, is a political analyst. I also have with me Sam Muizi. You said Mulindwa? Muizi Mulindwa is a name I hadn't actually gotten but I'm glad that I now know you in full. So let me just transition to the aspect of, I know it's a tricky one, this one I'm going to bring to the fore, evidence determination. Authenticity of claims is something that can be contested by any one person. If you took time and listened to what is claimed to be the audio tapes, the recordings that Kizza Besigye was apparently either negotiating or dotting the I's and crossing the T's on a deal that would eventually see the collapse of the government, the audio appears to have the phrase, we have the capacity to deal with the drone, but we need capacity to deal with the helicopter.
Yeah.
Civil society has funders from the West who have the ability to offer experts that can determine authenticity of tapes, audio recordings, and then from that point, a way forward can be determined.
Yeah.
I don't know whether you're the right person to ask this question, Mr. Chemoges, but has the civil society organizations and everyone else taken time to listen to these purported tapes and also verify their authenticity?
Thank you, Chris. You know, there's been a lot of there's been a lot of the presupposed evidence or materials that can be alleged to be used in this process, and many of them are out there, including the audio tapes. And again, you know, the role of civil society organizations are not just not NGOs.
That's right.
You have churches, political parties are part of the, you know, of the civil society. Going ahead to try now to go into the nitty-gritties of identifying whether these audios are actually true or not, I think to the extent that that's it's not your mandate, then you still focus on the process. But the biggest interest for those of us in this space has been three things. I think the first is on the process. I think that irrespective of whoever has evidence, the right platform is the courts of law. And that those that are accused, those who are accusing, and all the other parties, you have the right platform to do that. And that is the court. And unfortunately, we've not had an opportunity where all this is actually taken through, and we have the benefit of understanding what's happening. All what we are dealing with, all what we are seeing is pure politics and a lot of back and forth things. The substantive issues have not yet been handled.
That's right.
We are still into the other nitty-gritty. Secondly, whoever alleges really must be able to prove as the Constitution highlights, and that it's a burden of the person alleging to actually go ahead and prove this matter. It shouldn't be on the side of those of, and in this case, Besigye, who is being accused of having made those comments and that kind of thing, to come out and start saying how innocent he is.
In fact, given the national sentiment around the abuse of Besigye's rights, it will be incumbent upon anybody who is accusing him to come and say, hey, whoever is making noise about this man's incarceration, here is what we have against him. But if the president's words are anything to go by, that could tilt the security situation in the country. So maybe it is convenient to keep quiet and allow the courts to
the president is also, you know, the president also is an interested party. And that whatever he has, whatever information he has received from wherever, it should, the final destination is the courts of law. And that whatever information, whatever intelligence that the president uses should not be used at the disadvantage of the institutions or individuals in this country. That intelligence should be used to prosecute justice in the court of laws. And justice could go either way, you know. If the state has sufficient evidence to prosecute their case, then the right platform is, you know, as he suggests in his letter, asking who is delaying the process, who is causing all this delay. I think the answer lies really on the question of politics, how we've politicized the whole process, we've politicized the matter, and this even ceases to looking at it from a legal perspective would be very unfair, and as we've mentioned. And so, Chris, our interest really is on the process. Our interest is on ensuring that the rule of law is adhered to, and that the question of fairness, as seen in the Constitution,
when all that is laid, it allows for the contestations to come to light, and matters can be settled there. Okay. Counsel.
Yes.
I know this case is I don't know how, I don't want to say how invested you are in it. I just want to look at it from the point of view of a legal expert, somebody who is on the team and a lawyer as such. But sometimes the emotions do come through, especially when you have talked to a gentleman who has undergone untold battery at the hands of the state. When you look at the videos and some of the incidents that he has been involved with the state, if you're not strong, sometimes you can basically weep. A man who at some point had broken a hand was forced into the back of the pickup truck in a manner that was really unbecoming. So I know what you go through on a daily basis. But I know you told me something about when I asked about the evidence and how it was adduced at the General Court Martial. I didn't get that right. I don't know whether I'll be repeating that question or not, but I would be interested as a lawyer
to
listen to some tapes and whatever is put forward as the allegation.
As a lawyer, but first, everything about it, to start with the issue of, torture kills a case, however good. There are matters we've actually won because of the way the complainants, because it's the law. You torture someone, it kills the merits of the matter. At least that is the law when you come to the civil courts. That is why we are agitating to come to the civil courts.
It kills the merits of the matter
even
on the accusers.
If any, yes. If you have a good case, why then torture a person before prosecution? But we are seeing a complainant being the judge in the letters and everything which is happening. Is the prosecutor, is the judge. And our client, partner in this, the retired Colonel Dr. Besigye has been very clear to us that he's facing a ruthless man. He knows that the worst, he will tell you he knows that the worst can happen when it is about that seat of his that he holds dear. When we go back to the legalese, of course we shall look at the integrity of the recordings. That suffices, and that is not a matter which that court even had capacity to handle. It was very apparent. One of the areas which need a lot of specificity in handling, expertise in handling, are matters that deal with data.
Okay.
Because I don't think it conforms, what we are talking about conforms even to the Electronic Transactions Act. If you read it later by later. Because it talks about the collection, the storage. The chain of evidence has already been altered. For example, now, if you're transferring this matter to the civil courts, are you saying police will go back to Nairobi? There is not a scene of, we are talking about a scene of crime which has already been tampered with, it has been contaminated. We shall talk about the chain of evidence which has been altered. Are we seeing police going to investigate in Switzerland, going to Greece? So it is very apparent as far as this matter is concerned. We cannot even discuss merits. It would be dead on arrival, even if there has to be a case. We do not, as the legal minds, would not see it being sustained technically, especially in the hands of the civil lens. Those are the civil courts. Technically, any lawyer probably would understand. But the integrity of that recording will be key. We have artificial intelligence in this. That is why it needs a lot of expertise. Not one of the General Court Martial, where you don't have lawyers.
Where you don't have... All right. Thank you very much for that, gentlemen. I'm afraid we are out of time, but we shall be following events and developments as this goes on, especially the decision that is anticipated and expected for today. Many thanks. Samwizi Mulindwa, lawyer for Kizza Besigye, you're part of the legal team, and Mr. Timothy Chimongis, many thanks for your submissions too. It was emboldening and helps us understand.
You're also lawyers for the Karakunas.
Your lawyers for
and the NUP.
Karakunas and NUP.
Let's think about all the people who yes.
All right, thank you for that clarification. That will do it for the Kickstarter discussion. As we go into the break, we shall be preparing to listen to, or from rather, our man, Ivan K. Walinyolo, who will be talking to the Deputy Mayor of Entebbe, and the issue in Entebbe is regarding a road that apparently has a lot of issues. You know, when funds are released and roads are supposed to be worked on, but somehow, somewhere, that doesn't happen. We shall be trying to go into an introspection on that with our man, Ivan K. Walinyolo, after the break. Stay with us.